Okay, good morning, everyone. We are on the record. Today is Monday, the 12th day of July, 2021. This is a regular municipal council caucus. I had a scheduled 10 a.m. start. The clock on my computer is showing 10:03 a.m. In effort to adhere to social distancing protocols and best practices imposed by the city and state authorities, the city of Jersey City has canceled all public meetings and closed non-essential services as of March 16, 2020, until further notice. As a result, this council caucus will be held virtually as a video conference with public access. May I have a roll call for the commencement of this caucus? Councilperson Ridley.
Here.
Councilperson Prinzary. I'm here. Councilperson Baggiano.
Here.
Councilperson Saleh. Not here. Councilperson Solomon.
Here.
Councilperson Robinson. Not here. Councilperson Lavara.
Here.
Councilperson Rivera.
Here.
And Council President Waterman.
Here.
We have 6 council members in attendance at 10:03 a.m. In addition, at its time of its preparation, the agenda of this meeting was similarly disseminated on Friday, July 9th, 2021 at 5 p.m. to the municipal council, mayor, business administrator, corporation council, and the local newspapers, and posted on the city's website. So I can certify as to our total compliance with the Sunshine Law. Council President, would you like me to take it from the top?
Yes, I do.
Okay. All righty. So on to our first reading ordinances. Our first reading ordinance is item 3.1, City Ordinance 21-052, an ordinance of the City of Jersey City and the County of Hudson, New Jersey, amending Chapter 182, Health and Sanitation, Article 4, Smoking of the Jersey City Code, requiring landlords of multiple dwellings to implement a policy regulating smoking within the building and to provide notice of such policy both within the lease agreement and the dwelling. Any questions or comments on this ordinance?
This is Councilman Solomon.
Yeah, could you explain it?
Yeah,
Go
absolutely.
ahead.
So I've been getting complaints from constituents around particularly people smoking marijuana in multi-unit buildings. And what this ordinance says, it basically just says that any building, the multi-unit building, has to have a policy on smoking for indoor spaces and common spaces in their lease. It doesn't say what the policy has to be, right? If a building wants to allow individual smoking in apartments, they should do that. If they don't have to. But we just want to clearly state it in the lease so that every tenant walking into a building knows what the rules are. And then if there's a dispute in the future, hey, my neighbor is smoking and the smoke is getting into my apartment and I think it's a problem, then we know what the rules are for that building. So it doesn't tell them what the policy has to be. It simply says you have to have a policy in your lease. There is a state law around smoking in indoor places, and obviously that state law supersedes anything in the lease. This would say that, they just have to state their policy for common rooms, for balconies, for individual apartments, any indoor spaces that are not covered under the state law.
Okay. All right. But I think with the marijuana, guidelines, I think planning may have something in it concerning that, because I know that's going to be a problem with landlords, not only tenants who don't smoke it at all. So I agree, they should have some type of common area where they can go smoke it if possible, because I know in housing authority they don't allow it at all. So it's going to be a problem. I could see this being a problem. Some people are going to be arrested just with smoking it because it's not really a federal law as of yet with marijuana.
Yeah, so there's obviously, this only covers residential spaces. So obviously the planning covers is the commercial spaces, those types of. Again, this doesn't say one way or the other. It just says, let's say I'm renting in Metropolis Towers, 270 Marin. When I sign my lease, it'll state what is the smoking policy, and it's in my lease, and now I know. And so if my neighbor is smoking or I'm smoking, there's just a set of rules and it just covers residential units. That's the sort of purpose, is to make sure that there's just a clear set of rules there.
Okay, I have no more questions. Anybody else?
Council President, you mentioned that planning may have, be working on something. Could they speak to that right now? I know that it's coming up in their ordinance. which is the
Right.
Next ordinance. But if they could speak
Right.
to that particular issue, I'd be interested to hear what
What their viewpoints are. Is Matt,
they,
is someone
Oh.
on?
Yeah, hi, council. So this ordinance, I haven't reviewed it, so I don't know the language, but it sounds like it sounds pretty clear from what Councilman Solomon was stating. I don't think that there'll be anything in the zoning ordinance that's proposed that would impact this or contradict this ordinance. Yeah, as stated, we're addressing what are called cannabis consumption areas in the proposed ordinance 21-053. Council President, you are right. So because public housing falls under federal jurisdiction, it's illegal to smoke even in a private apartment on a public housing facility or within a public housing facility. So providing alternate spaces through cannabis consumption areas is something that we will talk about today. But other than that, I don't see any contradiction or issues brought up by this ordinance and the one that's about to be presented.
Okay. All right. Anyone else? Did they help you, Rolando?
could someone provide, I'm sorry, could someone provide, Matt, you said that public housing prohibits smoking on its premises completely. Can someone provide the language on that?
I don't know if that's the policy, but because it's a scheduled federal drug or scheduled drug
Right.
at the federal level, it's still illegal on a public housing facility or within a public housing facility.
But did you say that smoking is prohibited completely in public housing?
Well,
It's
with
considered a
relation
drug.
to marijuana, which I think Councilman Solomon said was somewhat of the impetus for this ordinance. So I'm sorry if I'm not addressing tobacco products or other similar products, but I just
Okay,
don't.
so
I just don't know.
public housing. I'm sorry, Matt, when you spoke to public housing, you were just referring to marijuana.
Correct.
Okay, noted.
Okay. Anyone else?
Yeah, I have a question, with respect to, this, was the health department, like, Councilman, did you speak to the health department in reference to this, in reference to the ordinance?
So I haven't spoken to the health department, but again, this doesn't set any rules. It simply just states that buildings have to have a policy. But I'm happy to send it to them and get their input before second reading. And if there are any changes, this is not like one that needs to move quickly. So if we introduce it at first reading, we have a month until second reading. And if there are changes they'd like to make, we can make amendments. There's no rush on this.
That'd be good. And I think it's structured as well as, making it clear, like recreational marijuana versus medicinal marijuana in these places.
Yep.
So that you could understand that a little better.
Yep, that makes sense.
That's it.
Anyone else? Okay. All right, Sean.
All right, thanks, Councilman. We'll follow up with you on that.
Okay, the next item is item 3.2, City Ordinance 21-053, an ordinance amending Chapter 84 Alcoholic Beverages, Chapter 160 Fees and Charges, Chapter 304 Taxation, and Chapter 345 Zoning to establish regulations for cannabis establishments and cannabis distributors and authorize a transfer tax and user tax on the sale and transfer of cannabis or cannabis items by a cannabis establishment.
Good morning, council.
Good morning.
I'm going to just jump right into this. I do have a presentation, so I'm going to be looking to share my screen here.
Mhm.
And
Amanda, can you unshare your screen so then Matt? Oh, perfect. Thanks.
all right. So let me know if there's any lagging issues as we flip through this. I'm going to try to get through this presentation quickly, and I had the I'm fortunate enough to work with Nick Strasser and Amy Foreman on this effort, and they'll be handling the latter half of this presentation. This is
Can we get a copy of this?
yes, absolutely. Yeah, and there'll be I think there's another map that I want to send around that I'll be talking about later today and showing on my screen. So this is an omnibus ordinance. So we're talking about zoning, licensing, and taxation here. Many of the slides regarding the zoning or land use were presented to the planning board in June. And this ordinance, again, is 21-053. So I'm just going to briefly talk about legalization, then go into zoning and hand it off to Amy or Nick. So Governor Murphy, he signed into law legislation legalizing and regulating cannabis use for adults 21 years and older. That's A-21. And there's this opt-in and opt-out timeline, which you may or may not know, which really is putting pressure on municipalities to decide what they're going to do. And the deadline there is August 21st. So that's why you're seeing it before you now as we approach the middle of July. The no action result, so if municipalities don't do anything within that 100 days, then any class of cannabis establishment or distributor will be permitted to operate in the municipality, and depending on the type of establishment, be considered a permitted use in certain zones. And we'll talk more about what those classes are, and if you have any questions, we'll try to answer those. So if you don't do anything by that within that 180 days, then you're bound by a 5-year prohibition on opting out. And that is really putting additional pressure on municipalities to act. And so what we've come up here is we believe aligned with the voters of the state of New Jersey, we think is appropriate for an urban context like Jersey City. And I'm speaking with regards to the zoning. I'm less studied up on what's being proposed in the taxation and licensing, but we hope that you agree. So I'm just going to skip this local cannabis tax because I think we are opting into doing this transfer tax. I'll speak briefly on delivery rights here and later. So the state law actually prohibited delivery from or prohibited municipalities from opting out of delivery. So if a consumer or a resident purchases a product that's even at a store or dispensary or a cannabis retailer outside of town, that delivery service can still come and drop it off at that residence. There's additional information, and I've had a source of this at the bottom here. The League of Municipalities put together a pretty good website. So did the ACLU for New Jersey, and you can look those up if you have additional questions. Briefly, what our city planning timeline was, we had a meeting on the 8th and the 22nd of June. We addressed zoning at these two meetings. We fielded public comments in between. We received multiple emails, had in-person meetings, made some phone calls to establishments that are kind of in this space, but more in like the CBD realm right now, and then our operation in Jersey City. And we've made changes, and at the 22nd, the June 22nd meeting, the planning board made some floor amendments and made a unanimous recommendation to adopt council to adopt the zoning legislation. And again, just reminding you about that August 21st deadline. So I'm just jump right into the land development ordinance or the zoning proposed here. So I'm briefly going to talk about the state licenses and classes, which I think are important for you guys to keep in mind, especially as we move into licensing. What local considerations were made to craft this zoning, and then we can take a look at the retailer reference map, and if necessary, we can look more specifically at the language that's in the ordinance. So there are 6 class licenses or licenses at the state level. And you can think of the first 4 as more industrial in nature, class 5 as being more Main Street or storefront, and then a cannabis delivery service. So as I mentioned, it's state preempted, and we're purposefully silent in our zoning on this because it's not necessarily clear what form these will take. You could imagine a business that has a fleet of vehicles and set up drivers, kind of like a taxi fleet that does a delivery service, or like an Amazon that does a delivery of their own products, products they sell. Or it could be like an Uber type of business where they just have an office and they have drivers that use their own vehicles, and they don't need anything more than, a 300 square foot office. So it was really a hard use to kind of wrap our heads around, and we just stayed silent. So it's permitted, it's preempted by the state. There was really no opting out of it, so we didn't see any point in putting in more sort of performative measures or design standards on that use. Class 1 cannabis cultivator. So this is a grow facility. They grow, cultivate, and produce cannabis products. It has to be grown in New Jersey to be sold in New Jersey. And then they sell and transport that to growers, processors, wholesalers, retailers, but not consumers. A cannabis manufacturer, class 2, processes cannabis items in New Jersey and optionally transports those. A cannabis wholesaler, class 3, purchases or otherwise obtains, stores, sells, and otherwise transfers cannabis products. A class 4 cannabis distributor, it transports cannabis items in bulk intrastate, so it can't cross state lines for federal reasons, and from one licensed cannabis establishment to another. And I think class 5 is one that's probably at the forefront of most people's minds. Is the storefront. It's the cannabis retailer or dispensary. It goes by many names, but the state law says defines it as cannabis retailer. So this is where a customer would purchase or obtain usable cannabis from a store, and they could consume it at home. They might be able to consume it on premises if they have a cannabis consumption area. And class 6 is a cannabis delivery service. So we talked about that briefly, like the kind of Amazon fleet equivalent, or like an Uber fleet kind of equivalent. And some items to note here, that a consumer could purchase from a store, say they have a website, like a cannabis retailer has a website. Well, they could provide a third-party platform to deliver that to their home. That's an optional thing that a cannabis retailer can do. Another important note is that if a person purchases through a cannabis delivery service, to fulfill that purchase, that delivery service can go to a retailer and pick it up on behalf of that consumer, and that cannabis retailer must accept that purchase and fulfill it. So someone could do it from the privacy of their home, if need be, or for some other reason that they, or for convenience. I'm just going to stay on the line of kind of definitions here. So there's another, we were talking about state licenses and classes. So class 5, the cannabis retailer, can also receive a license to be, or a local endorsement to be a cannabis consumption area. And what this means is it's a designated location operated by that Class 5 retailer or permit holder for dispensing medical cannabis or recreational cannabis for which the state and local endorsement has been obtained. And they can be indoors within it in an area that has venting and meets, I think, the cigar lounge, the equivalent of cigar lounge venting requirements, or it could be an exterior area outside. And in the ordinance that we've proposed, we talk about performance standards or design standards for areas that would be on a rooftop or areas that would be in a yard. And we separated those out specifically because we're in an urban area. We saw that there's a possibility for a rooftop versus yards, and what does that mean, and how those should be considered. I'm sorry, I just downloaded this from online, and it kind of messed with my formatting here. But another definition that we wanted to talk about is a micro business, which is used in the zoning. And it's important, and we call it out for a couple different reasons. One, it's built or it's built or incorporated in the state law to promote equity and entrepreneurship.
I'm sorry,
And
can I interrupt? I'm sorry, this is Councilman Navarro. I
Sure.
can't see the full slide. I don't know if it's just on my side or if others gets cut off at the bottom on this one.
Yeah, I will try to fix that before I send it out to you. I apologize. I don't know if I can fix it on the fly, but there we go. All right. All right. So we call this out for entrepreneurship and equity reasons, but we also call it out in the zoning because there's operational or capacity or quantity restrictions that are incorporated or put upon this definition of a micro business. So I think important to note, 100% of the ownership interest in a micro business shall be held by current New Jersey residents who've resided in the state for at least the past 2 consecutive years. And then at least 51% of the owners, directors, officers, or employees of that micro business shall be residents of the municipality in which that micro business is located or to be located. And then on the more zoning side or capacity side, I'm sorry, that's a mistake there in the language. I wanted to, this thing which pertains to cannabis consumption areas meant to be deleted. I'll just move on to this. The capacity issues are there can be no more than 10 employees. The space that we're talking about is no more than 2,500 square feet, and it depends on what license you have, but I underlined the one for cannabis retail. There could be no more than 1,000 pounds of usable cannabis each month at that location. So there's some caps on the intensity of a micro business use versus a non-micro business cannabis establishment or distributor. So we call that out specifically and allow for more opportunities for them to occur in different parts of the city because of that equity and entrepreneurship reasons built in. Okay, which leads right into some of the local considerations that were guiding the zoning that's before you. So we built in public meetings and notice. So for all the classes 1 through 5, again, we're silent on class 6. We're permitting them in this ordinance as conditional uses, which per state law requires a public notice. So within a letter to 200 people within 200 feet, and a notice in the paper, and a public hearing before a board. We did that on purpose. That's by design. to allow people to receive that notice and an opportunity to attend a meeting and put their comments on the record, and also feed in a couple performance standards and design standards on top of those classes and those uses. So again, and as it just stated, promote equity and entrepreneurship. So the main way we're doing that is by really focusing on the microbusiness license or permit that's defined within the state law, and kind of allowing for that to happen in more places in the city. So it almost, in a way, and by design, allows them to have like a first bite at high value areas or high traffic areas, and a last bite to set up a shop, which might be the case if these are smaller, more entrepreneurial endeavors. It might take more time to set them up and open up shop, and so we really wanted to focus on allowing them to come in first and last, and we think the ordinance does that well. And so these bullets on the right address these next three considerations. So recognize concern and existing conditions, balance demand and oversaturation, and encourage competition and co-location. So these three kind of go in tandem in many ways. And the zoning ordinance is broken out by classes 1 through 4 and standards regarding those. Classes 1 through 4, which are micro businesses and standards for those. Class 5, the cannabis retailer, which are also micro businesses, and then ones that are not. And through regulating what zones those can be in, separation distances from schools and from other similar establishments. We feel like we're recognizing that concern. We're trying to balance that demand while warding off oversaturation. We want, a healthy mix of businesses, restaurants, retail that serves many different functions on a block, and we wanted to make sure that we don't push the market too far towards this, which is new and kind of unknown, and we don't really know what would happen if it was just unleashed. And encourage competition and co-location. So I think co-location speaks more to the class 1 through 4, the industrial type uses. So you could see how a grow facility, a grow facility would want to be right next to a manufacturing facility, or the other way around. So you get that co-location, that cohesiveness of businesses that might benefit from being close to one another. And on the opposite end, competition, we want to make sure that we have the best or the most responsible cannabis retailers in the city, and by allowing competition to happen through the zoning ordinance, we hope that occurs, and we do get responsible and good cannabis retailers in Jersey City. I just had a couple more. So last local consideration is to recognize medicinal safe space needs. So that was talked about at the last ordinance just briefly, and I'll just reiterate it again. There are cannabis consumption area standards in the zoning ordinance, and in many cases that might be the only safe space for residences or consumers to consume that product that they are purchasing, because of law, because of reasons with their lease, or just because it's a safe space. With that, I can bring up, I think I will bring up just briefly the retailer reference map. And if there's any questions, I can go, or if we want to hold them to the end, we can circle back, but then we can go to any language in the zoning that you might want some more explanation on. All right, so this is just the cannabis retailer map, and I sent this out on Friday, and it's been tied to the distribution materials we sent to our planning board. But I can send this out again or make sure that it's easily available for your review. I'll just explain it briefly. This map actually hasn't changed since May 27th, but the gray areas and the green areas are of the most, I'd say, most concern for you to review. And let me just zoom in here. I'll do just Journal Square. So gray, we tried to map all the areas in the city that allow for retail use, which is where a cannabis retailer could potentially be located. In addition, the green areas are neighborhood commercial areas, so they could also set up shop there. The blue per ordinance are the school facilities that are recognized by the municipal council, and the buffers are 200-foot buffers from those school facilities. So the main entry door of any cannabis retailer would not be able to be within this buffer area. So that's the purpose of this retailer reference map. We also have the ward boundaries here. And just since I'm on the map, I will briefly just scroll out and say that the green areas are highlighted in particular because those are the neighborhood commercial areas. And there's at least, they're geographically distributed through every ward at maybe not equally, but there's one NC zone in each ward at least. And we are allowing for micro businesses in those areas to, more of them to set up shop in those areas, as well as in the gray areas they're allowed, but we emphasize those areas as well as that's what these station areas are also emphasizing, is more opportunities for those micro businesses to set up shop. All right, with that, I'm going to go back to the presentation and I'm going to hand it off to Amy or Nick.
Hey, good morning, everyone. Just following up with Matt's part of the presentation, it's important to note that you've got 4 separate portions of this ordinance. You've got the zoning portion, the amendment to Chapter 345. You have the amendment to our alcoholic beverage section, which now is going to be alcohol and cannabis. You have the taxation piece of it, and then you also have the fees piece of it in Chapter 160. So Matt covered the proposed changes to Chapter 345, and I'll be handling the remainder. Now, just as an overview, the one thing that's important to keep in mind is the state is granting these licenses to the recreational cannabis operators. What they're looking for from the municipalities is 2 things. 1, does their proposal comply with the zoning? And 2, is something that the municipality is willing to endorse. So it's 1 is is completely zoning related. Is it appropriate for the zone? Does it meet all the requirements? Have you gone through the planning board for the necessary approvals? That piece of it. But then you have the endorsement piece. So what we have here is we've created by the ordinance a cannabis control board modeled on the ABC board. And the membership consisting of 3 members appointed by the mayor with the advice and consent of council. Now the 3-year terms, the first terms, 1 person of 1 year, 1 person of 2 years, 1 person of 3 years. And after that, it'll be 3 years for each. Make sure there's a staggered term for 1 person being reappointed per year. The responsibilities of the CCB be reviewing applications for municipal support of the operation of cannabis establishments and distributors, and reviewing the applications for the operation of a cannabis consumption area and issuing the cannabis consumption license or endorsement. So back on the next slide, please. Thanks, Matt. Okay.
Sorry,
so
there's a delay.
That's okay. This is the process. So as I mentioned, the state is responsible for issuing a license for the operation of all cannabis establishments and distributors. And the city and the CCB will review these applications to ensure compliance with local rules and regulations. And if the application complies with local rules and regulation, the CCB will notify the state that it supports the application via a board resolution. So this is going down the bottom here. This is the process. Application sent to the state reviews and sends it to Jersey City. Hey, we got an application for Jersey City. We need you to take a look at it. The CCB reviews the application in firm compliance with local rules. At the same time, also zoning will be going through its process as well. If the application complies with local rules, the CCB will approve via resolution. If it does not comply, CCB will deny via resolution and forward that resolution to the state. And at that point, the state will approve or deny based upon the feedback from Jersey City and its own review. Now, the one thing to keep in mind is, while the process is set out this way, it'd be very unlikely that a cannabis operator would not have any contact with anybody in Jersey City during this process by just us getting an application from the state. So this is the operators who want to operate in Jersey City will likely be in touch with Matt, will likely be in touch with the city and say, hey, this is what I want to do. But the state law specifically lays out this requirement. That's not to say that there wouldn't be contact with the city with people who want to do business in Jersey City for this process. Go ahead, Matt. Okay, so now this is the standard by which, by the ordinance, the CCB is evaluating these applications. We have an application annual fee, financial information, making sure that the business is financially viable, disclosure of any criminal or quasi convictions of those operating the business, proof of compliance with all local regulations, proof of approvals from the planning board, any other necessary board approvals, and description of odor mitigation and security practices. Next slide, Matt. Okay. Also, a community impact, social responsibility, and research statement, which shall include a community impact plan summarizing how the applicant intends to have a positive impact on the Jersey City community, description of the applicant's record of social responsibility, philanthropy, and ties to Jersey City, description of any research description of any research the applicant has conducted or supported on the adverse effects of cannabis use, substance abuse, or addiction, educational activities, and a plan describing any research on effects of cannabis use and substance abuse and outreach activities which the applicant intends to conduct, including the applicant's plan to implement or contribute to educational or training programs for individuals formerly sentenced for marijuana-related charges, to teach those individuals the legal marijuana industry. So this is a very big portion of this is the social justice piece with recreational marijuana coming into legality. Okay. Also, a workforce development and job creation plan, an attestation signed by a bona fide labor organization stating the applicant has entered into a labor peace agreement, and all other documents or information the city may deem necessary for a comprehensive review. Some of you have contacted me asking about the labor peace agreement. We have it baked into our ordinance, but it's also a requirement of the state. Unless you have a labor peace agreement, you're not going to be a licensed operator in the state of New Jersey. Go ahead, Matt. Okay, now going on this is specifically for the cannabis consumption areas. Now these are designated. Matt kind of did the definition a little earlier, so I'll gloss over that. But they have indoor or outdoor. Indoor structurally enclosed area with medicinal dispensary or retailer must be separated from the area in which retail sales or dispensing of cannabis occurs and only accessible through an interior door after first entering the retailer. Outdoors, an exterior structure on the same premises of the cannabis retailer or medical dispensary, either separate from or connected to the retailer or dispensary. Okay, next slide. Okay, now this is one piece where it's the state and the municipality both need to be in complete concert to allow a consumption area. So there must be an endorsement of both the state and the city to allow a consumption area, and the city's endorsement shall be valid for 1 year and shall be accompanied by a cannabis consumption area license. The Cannabis Control Board shall grant the city's endorsement in the form of a board resolution and shall issue the cannabis consumption area licenses within Jersey City. Go ahead, Matt, next slide, please. Okay, these are very similar, but to the ones I described earlier for the class 1 through 6 licenses. Annual fee, discussed a little later, and more in detail, general information, disclosure of criminal or quasi convictions, odor mitigation, description of proposed location, relevant land use approvals, copy of the class 5 retailer license associated with the proposed consumption area, and safety and security plans, procedures, and all other documents the city may deem necessary to do an appropriate review. Next slide, Matt. Okay, now this is also important. So if the consumption area is approved, but for some reason they are failing to live by the obligations of either the state or our local requirements, the CCB may deny or revoke the license and the endorsement anytime for good cause. If the applicant does not receive approval from the city within 1 year after the date of the state approval, the state endorsement shall expire and may not be renewed. If the application is denied by the city or the approval of the city is revoked, the state shall also revoke the state endorsement. And if the applicant may file a request for a hearing with the Superior Court within 30 days of a city's denial. Again, this is specific to the consumption areas. Now, these are the general regulations that are set forth in the non-zoning portion of the ordinance. So it sets times for Class 5 retailers, indoor cannabis and outdoor cannabis, odor mitigation requirements, to have equipment to mitigate the cannabis-related odor. Okay, and the ventilation system must be improved by Department of Health and Human Services. Security must be secured and have full-time security protocols in place, and the security system must be approved by the Jersey City Police Department. And for public consumption, this kind of goes back to what we were talking about a little bit earlier. With the exception of the cannabis consumption areas, public consumption, smoking, vaping, and aerosoling on any cannabis item is prohibited. This includes city streets and city parks. In terms of what we were describing earlier for private residences, that's up to a private residence. If a apartment building, as Councilman Solomon said earlier, in terms of tobacco, actually kind of dovetails nicely to make sure all residents are aware of what the policy is regarding cannabis consumption in that private residence that may be owned by maybe run by a large apartment complex or small apartment complex or multifamily home. Okay, go on to the next. So this goes into the fee section. The application fee is $2,500, and then the annual fee for those that are approved. These are the fees set back for cultivator, manufacturer, wholesaler, distributor, retailer, and delivery. The annual fee for a consumption area license is $25,000 to include an escrow fee of $5,000 for the necessary reviews that will be drawn down as the city does its necessary reviews, and then maybe raised or refunded depending upon what's left of the $5,000 once the application review is complete. Okay, next slide, please. Okay, this goes back to the tax. I know Councilman Lavarro has already proposed essentially what is contained in this ordinance, but he has a specificity for as to where the money goes. This ordinance, as it's currently drafted, is just the city will collect this. I know the council there are many different ideas as to how the tax should be spent. The most important thing for purposes of August 21st is to make sure that the approval of the tax is passed from a legal point of view. There's nothing stopping a separate account will be created with collection of all the recreational tax revenue and put into a separate fund to be discussed as part of the budgetary process each year. 1 year you may want to do one thing, and next year you may want to do something different. So there is nothing stopping a delay or a wait and see attitude in terms of how much revenue is and what the needs are at that time, or if the council sees fit to specifically designate where all the recreational revenue would go in the same manner as it did for the medicinal marijuana tax, in which all of the revenue was put into the city's affordable housing trust fund. So that's up to the council, but I would just caution, please don't not pass the tax at all prior to our expiration date of August 21st. Next slide, please, Matt. Okay, going back to the numbers, we took them straight from the state law. The use tax is a little bit different in that you have this is for in event one, owners own 2 separate facilities within Jersey City or even outside Jersey City and are transferring it within their operations. So it wouldn't actually be going through the retail or sale process. Just make sure that those transfers are actually captured for purposes of the tax. So. All right, so that's complete the slideshow. I just want to say thanks and great job to Matt. The city had 180 days to put this all together. We're well short of that. Make sure you guys the council had plenty of time to review and take action to make sure we don't miss that August 21st deadline. And Matt and his team put an enormous amount of effort into it. So thanks and great job to Matt and his efforts.
I have a question.
Mm-hmm.
All right. Nick, quick question. Who is going to be inspecting these things? I haven't heard that the Health and Human Services is involved. I haven't heard that the quality of life people are involved. I mean, it's Matt, are you the point of contact for this? Because And have you spoken to the the Health and Human Services and the Quality of Life people with respect to this, like ABC, you know, is the state going to inspect? Yeah, I mean, I'm just a little lost there.
Well, Catherine, there may be inspections from the state level. Obviously, if they're going through a planning board approval, Matt's team will make sure that all the planning approvals are complied with. And that's one of the benefits of going through the planning board process for each of these operations as a conditional use, is that all requirements of planning need to be undertaken. In terms, we specifically put in terms of the review by Jersey Police for security and HHS for the odor mitigation pieces of it. And we have the regulations in place during the course of this ordinance to ensure proper enforcement, to ensure that the operation is rolled out properly and the benefits of recreational marijuana are met, but not any of the burdens that obviously everyone is concerned about.
So with this ordinance, was the Health and Human Services and the Quality of Life people contacted?
With regards to zoning, no. And with regards to anything that would constitute a zoning violation from what is being drafted or proposed in this ordinance, the Division of Zoning would be the enforcement arm for city planning.
Mhm.
No question, no other questions.
Someone else?
Yeah. There's going to be a lot of problems because of this. Most of you don't remember the 60s, and there's going to be a lot of major problems arising out of this law.
Okay. This is Councilman Navarro. If I can just go back to talk about deliveries from out of jurisdictions. Are those transactions taxed through our ordinances or through the state, or how's that work?
It's my understanding, I'm going to jump in, Nick, that we don't actually tax the delivery at all. It all goes to the state. Is that right, Nick? I believe that's my read on the state law.
Nick?
Sorry,
You're muted, Nick.
I'm just going back to I'm going back to the slide. I think it had the information regarding.
Mhm. And Matt, when you send the presentation to Desiree, she'll send it out to all of us.
Yeah, I think I'm
Yeah.
looking at slide 38, Nick. I'm seeing the transfer tax rates. It's 2% for cannabis cultivator, 2% for cannabis manufacturer, 1% for wholesaler, and 2% for cannabis retailer.
Yeah,
So
that is
not-
that is absolutely correct. What would happen, that would go through the retail process, but it wouldn't be specific to the delivery operation. So if you're buying it, you're going through the retail process, but there wouldn't be an additional tax upon the delivery.
Is anyone taxing, whether the state or anybody else taxing on the delivery portion?
I don't believe so. The language we took for our taxation ordinance came directly from the state. So I do not believe, because essentially if you're doing the delivery, you're taxing over and above the retail. So whether you pick it up yourself or it's delivered to you, there's no additional tax. I believe that's the intent of the state. And like I mentioned, the numbers in terms of those percentages, we took them directly from the state law.
But let me ask this question because there is a concern with HHS because normally they do send out enforcement in certain areas when it comes to retail and things like that. So what role will they play? You know, are they a part of this? That has to be clear. You know, if they are part, then they should have been at the table with some discussions to see how we can do this when it comes to retail. If not, then, you know, we need to go back to the drawing board. So what role will they play? Come on.
Well, the state heavily regulates all these operations and inspects them regularly. We would obviously do what we do on our end of it, as we described in the ordinance in terms of our internal city regulatory features. Now, the one thing I would just caution, we just said, Council President, is it's time to go back to the drawing board. August 21st is our deadline.
I know.
So,
Yeah.
I mean, one thing I would caution the council on is if you're not ready to do this, what a lot of municipalities are doing is opting out with the intention of fully going through a conversation and coming back in at a later date. The intention of most people we've talked to, and I think Matt would agree with this in terms of internally within the city, the council, and the community, wants to see us to move forward with this within the August 21st timeline. What I would just caution the council of is not doing, please don't do nothing. Is if you're going to opt out, we'll review it in the fall or next spring or whenever the council is comfortable. But really doing nothing at this point, all that's going to do is allow the operations to go in place without the city setting any regulations whatsoever, as long as, as Matt said, as long as it complies with zoning. So if you got a retail area and they want to do retail, they're going to be able to do retail. If they have a wholesale area or a industrial area, they're going to be able to do their grow operations or cultivation. So you want to make sure that you don't lose the opportunity to have this look how you want it to look in terms of the regulations the city is putting into place. So I would just caution the council to be wary of saying we're not ready, so we don't want to do this right now, because the August 21st deadline is a significant thing to worry about.
I mean, the ordinance is good. I like the ordinance. My concern is that I don't want to get to the finish line and I really don't win because all my T's weren't crossed and all my I's weren't dotted. I just want to make sure that, that the health department is on board, Quality of Life is on board, so we don't have to, like I said, get to the end and then we have to look back to make sure that we did everything right.
Right.
Can we just,
This is Councilwoman Prinzeri. Just to also kind of piggyback off that for a second, if we're looking at consumption and consumption lounges, that would, to me, would fall under Health and Human Services and or Quality of Life as it relates to some of the permitting and some of the inspections. So I think that, the inclusion of Health and Human Services is going to be really important. And no matter what we do moving forward, and whether it's addressed specifically here or whether it's addressed in an amendment afterwards. Just because, I've got my own concerns about consumption lounges sort of all together, where they're going to be placed, but that's not necessarily part of this conversation right this minute.
Yeah. The one thing I would kind of go back to my previous point. I understand the idea of let's do this and we'll kind of tweak it later. The one concern is, as Matt's slide said, one of the very first slides is the regulations need to be in place by August 21st. And the idea is to make sure that anybody who's going into this business in Jersey or anywhere else in the state knows full well on August 21st, this is what I need to comply with. And change, maybe we'll make some minor changes that are not going to affect the actual business operations at a later date, but please don't bet on it. Please don't vote on this. I kind of like it, but I would like to make it better later. Let's make it as perfect as we possibly can. If you feel you want to opt out and then make it perfect in October, November, that's an option. But what's really not an option is to pass this and say I really wanted something very different. I want it in the fall. I want to change it. Let's try to make sure we do the number of changes are as minimal as possible, so as not to run afoul of that August 21st deadline, and making sure that our policies and procedures and regulations are in place at that time.
I'll just second Nick too. I think that there is we can coordinate with HHS and make sure that we're doing everything correctly. This, because it's they're selling consumable items, there might even be an ordinance on the books that pertains to this with regards to inspections. I'm not well versed in that portion of the city's municipal code, but we can definitely reach out to HHS and see what needs to be done.
Okay, do that, Matt, because we need to really know that. Is there any more questions?
yes, I have several questions, if I may. But just to follow up on what all of you were saying with regard to HHS and quality of life. So to Nick, if this ordinance should be adopted without, say, major amendments or ultimately before the August 21st deadline, then the council can still amend portions of this ordinance or other ordinances to allow for stronger inspection and monitoring, et cetera, and enforcement of these establishments?
Well,
after
what I'm
that
saying,
deadline?
my point, no, I think the opposite is true. Because we have the August 21st deadline set by the state statute to establish our local regulatory framework and opting into the recreational cannabis program, we need to have everything squared away by August 21st. The other option, which is what a lot of municipalities are doing for the very things that you're talking about, they're saying we're going to opt out because we can always opt back in at our convenience and at our leisure and when we're comfortable. So if you're not ready to do this and you have concerns, that's understandable. This is a very fast timeline that we're operating under, and it's imposed by the state statute. So, but what you should do then is, if you're saying, I'm not ready for this, opt out and say, we're not going to allow recreational marijuana in Jersey City, because then you can opt in at a later date. But once August 21st comes and goes, whatever you have in place at that time, that's what you've got. And if you do nothing, nothing is in place, and the only thing that you'll be the retail or these operations will be guided by is land use and the zoning operations. It makes, I know it's very confusing. It's very unusual to have the state impose this deadline, but that's where we are. Does that make sense to everybody?
That makes sense to me. So whatever we have on August 21st is what we have.
Correct.
Correct.
And if we want to, unless we opt out.
Right.
Correct.
Yeah. If you do nothing, you're in. And then you've lost the opportunity to put any kind of local restrictions on.
You do it, yeah.
And you're governed by what the state does and your local zoning. You can't put a commercial area or a grow area where there's retail, or industrial where there's retail, and vice versa. But other than that, that's what you've got. So I understand this is a lot. I understand it's comprehensive. We went through a long presentation this morning. There's a lot going on here, but just be wary of that deadline and how the council would like to handle this.
So amendments to this.
Go ahead, Danny.
So amendments to this ordinance and conversations with the other departments should be done then, prior to August 21st, and then restructured, and then then to have the amended part. Is that what you're saying?
If you do not, I'll put it this way. I think maybe the way to look at this is there anything in here that you as the council would like to see different or concerned about? If you're concerned about the coordination within the internal city departments and divisions to make sure that everything is enforced the way you want it, then we can have those conversations, and then we can have those conversations, because really that's an internal executive authority conversation as the practice of how these things are going to be enforced. But I would caution you to say, like, well, we'll pass it now and we'll make significant changes later when we're you don't want to do that. Right. You don't want to do that because of the way August 21st has been written, where the expectation is August 21st, you're going to have what you want in place at that time.
So I think what we really need to do is have HHS weigh in on it. So Matt has to speak to them. And then I know we have a meeting at 6 p.m. concerning, this marijuana issue. At that time, we can really discuss it. Do we want to opt out? Because I see if we opt out, we still have time to do what we need to do. Opt out just giving us more months if we're not clear on exactly what we need to do. If we do nothing, then it's like full steam ahead. We don't have no restrictions in our city. Correct?
That, Council President, you said it perfectly. You can opt out and make it perfect at a later date if you want. You can do basically, we tried to give you the best of what we could do within a limited time period, as we've given you today. But if you do nothing, then it's, like you said, full steam ahead, and there are no city regulations regarding the operation of marijuana except for zoning.
Okay. So I think they need to speak to HHS to see the enforcement issue, and then we need to discuss it at 6 o'clock. What are our concerns as a council? Because this is not no easy issue. This is something that we really need to really think about. So
I'm happy to.
Okay,
I'm happy to discuss at 6 o'clock, but I think, and maybe Sean can speak to it, we did advertise as relating to the transfer tax itself, I think, or did we not? Or did we speak about it more broadly as cannabis legalization?
It's specific to your ordinance.
Yep.
okay.
That's what I was told to advertise.
No,
and
that's
right.
exactly what I had asked.
You're
you to do,
right,
so I
Sean.
appreciate it.
So, I
And
mean,
I'm happy to talk about it some more if Council President, if there's another meeting, but I don't know that legally we're permitted to
right,
kind of
I
have a
got
broader
you.
conversation. But
I got you. So,
that-
I mean,
that
I don't
being
have
said-
no more questions. I got a clear understanding which way we have to go here. I don't know if anybody else have questions concerning the presentation and this ordinance. I think that's what our concern is.
I do.
Go ahead, answer
So-
your question. Ask your
So
question.
just to
Ron.
clarify for me, if somebody is applying for one of the licenses or permits, they go to the state first and then it comes to the city, or is it vice versa?
The way the statute reads is that they go to the state first, and then the state will then forward the application to us to make sure that the application comports with everything that the city requires, both from a zoning standpoint as well as from our regulatory standpoint, as we've gone through today. However, I would think it's very unusual that a cannabis operator would go to the state with a Jersey City application, having not talked to anybody on this call, not talked to planning, not going through the process of talking to the folks here in Jersey City to say what their plans are. So functionally, by the letter of the law, it goes to the state and then it comes to Jersey City. But most likely, when that application comes in, we're probably going to know who that operator is. They've already been looking at properties and talking to the folks in the city about what they'd like to do.
Okay, so once it comes back to the city, then the city has up to 1 year, if I read that correctly, according to the ordinance we've written, to respond. Is that accurate to make a determination, I should say?
With regards to the zoning application or the application to planning board or zoning board of adjustments, we're bound by the MLUL that deadlines. So it's going to be much shorter than that to review an application, see if it's complete. And if it is complete, then there is a time that the board has to act on that application.
So there was something in the presentation where it said the city has 1 year.
I think that was in reference to more licensing, Nick. But to answer your question on the zoning end, we're bound by another state law, the MLUL.
Yeah, I'll double check the year timeline in the presentation. I'm not sure exactly where it is, but the one thing is also keep in mind is that these things will likely be going concurrently, where they're going through the process of going through zoning and planning and getting all those applications. You know, the Cannabis Consumption Board is also going to be likely reviewing things at the same time to make sure, and the application process of all those requirements and the financial documentation and the background checks, that's all things they've given to the state. So it will likely, a lot of these things will likely be happening concurrently, but I'll double check the actual deadline of what the city has to take action by.
Okay, so I'm just going off of what the presentation, I don't have it in front of me, but I recall seeing there that the city would have, after the state, that the city would have 1 year, and that if the city doesn't respond, then it's approved. I think it was what was written there. I'll just add that if that's our discretion as to how long that period is, I think 1 year is too long. And then it's a question of if the city can respond, for example, if there's a permit application and something is missing, and then they're just informed after 1 year that remit this other missing information, or you have to or this is what you need to cure your application, or something to that effect, and then the clock starts ticking again. That's not clear to me. So what I don't want to end up in is a situation where someone's application just keeps dragging out for years, and we should be more streamlined than that, kind of moving forward. Can I ask about the going back to kind of deliveries again? Well, let me just go back to all of the different types of businesses, cultivators, distributors, et cetera. They're all doing business here in Jersey City, so I would assume the payroll tax applies to all of them. Is that accurate?
Yeah. Marijuana or cannabis businesses that are, the payroll tax applies the same way with any other business, whether the standards of the payroll tax would apply, and the payment of payroll tax would also apply.
So does the delivery service, if it's out of jurisdiction, if they're delivering within Jersey City, do payroll taxes apply to that business that's not in?
It would matter where the person was directed from. So if I have a delivery operation in Jersey City and I'm taking my delivery operation, you're going to go outside of Jersey City's borders and deliver it, because that person is directed from Jersey City, that the payroll tax would apply. If you're someone from outside of Jersey City delivering to Jersey City, because that person is employed and directed from outside of Jersey City, the payroll tax would not apply.
Got it.
And that's consistent with the exact language of the payroll tax.
Right. With regard to micro businesses, who will determine that someone's met the criterias for being a micro business? I don't recall what the exact criteria were, but it came up in the presentation. And that residency was one of them. Who's determining that they've met the 2-year residency requirement?
Well, they have to receive that from the state. So the CRC will be determining whether or not they meet microbusiness status. And if they don't, and they attest to being a microbusiness at a local level, I would assume that's grounds for revoking all licenses. So we'll take some coordination, but the way that at least the zoning ordinance is drafted is relying on the CRC, the state licensing or review board or review commission,
to determine if they're a micro business.
Correct, but they'll have to affirm that they are locally by affidavit.
Is
or
that within our discretion to
sure
evaluate their micro business eligibility?
Oh, yeah, I would think so. Yeah, sure. They need the board. They have to go before a hearing, before a planning board or zoning board, and I think it would be very appropriate for the board to make sure that they affirm that they are a micro business on the record.
So are there, does the law allow for more than 2 years or at the city's discretion to establish micro business, or is it very strict in that regard?
I'm not sure I understand that question.
Could we define a micro business as being 5-year residency?
I think that's better question for the law department, but I think my general read is that you can't go above and beyond the state law because they're the sovereign.
Yeah, I agree with Matt on that. The micro business definition is specifically articulated in the state law, and I don't think we can go stricter or more lenient based upon what the exact definition of what the state has put on micro business. But I'll double check, but I don't think we're going to be able to change that definition in any way.
Okay, if you could double check that for me, I'd appreciate that, and just give me your opinion on that. My concern is that we're just going to have an influx of folks who are going to come here and establish residency on paper or otherwise, saying that they're residents, so they can get a first and last bite at the apple there to set up a business. People from kind of outside interests and so forth around that to do something like that, and meet the eligibility criteria around micro business. Let me ask about all of this applies
Anybody
to
else got questions? Wait a minute, Rolando. Do anybody else have questions? Okay, go ahead.
Does the so all of the ordinances being proposed apply to recreational, not necessarily medicinal, or do they apply to both?
Recreation.
Just adult use.
Yeah, an adult use under the state vernacular is recreational.
Do we have already laws in place on medicinal?
We do not have any local control on medicinal over and above what standard zoning has been and what the regulations are at the state level at this point.
Okay.
Yeah.
And I will go into whether.
Go ahead. I'm sorry, Councilman. Go ahead.
Yeah, I'm just curious if and I'll talk offline about the medicinal piece, but I'm curious about establishing rules for medicinal, particularly separation as it applies to churches and schools. Can you speak to how the ordinances you're proposing will apply to potentially pop-ups or mobile trucks or anything like that? Mobile vendors?
Based upon the rules at both the state and local level, I don't see a mobile cannabis distributor being allowed. That would have to go through the planning board approval in terms of municipal land use law, and I don't see that being able to be. I don't see that being possible. And in terms of pop-up, these need to be permanent locations as to where they're getting their approvals from. Where are you be located? What are you be doing? What are all your requirements? And those approvals cannot be granted for something that is not stationary. Matt, will you agree with me on that?
I'd agree. I don't, there's nothing I read that would speak to a mobile pop-up or truck.
So they're prohibited.
I mean, it's silent is what I would say, but I don't think any license that they've defined in the state law would address that type of business. So they can't grant a license if they don't have one.
Yeah, it's not explicitly prohibited, but I don't see how they would actually be able to go through the process and get the necessary approvals to operate such a business. I guess probably, I think that's the way I would look at it. But if it's the intent of the council, that is actually one regulation, probably relatively easy to put in by Wednesday to say, that there will be no mobile operations for this other than for delivery.
Did you say the CCB is a three-member board?
Yes, there's a 3-member board appointed by the mayor with the advice and consent of council, and it's modeled off the 3-member ACB board. So that's where that structure came from.
ABC, I mean, was that mandated by the state in terms of the structure of that, or that's something?
The distinction, like Councilman, you're actually right on point. The ABC board, that is mandated by state statute. We just use that as a structure in terms of creating the board here for purposes of this at the municipal level. But it is not required to be a 3-member board. We just created that internally based upon the state statute for ACB.
So similarly, if whatever we adopt, if a CCB should want to be amended at a future date later on, if this should be adopted, then could it be amended, or we have to wait a certain period of time?
My preference is to get everything in perfectly before August 21st, or opt out and then getting it perfect after that. I really am reluctant to give any kind of recommendation as to what will be okay to change after August 21st and what won't be. So my preference, like I said, would be to let's get everything perfect by August 21st, or opt out and get it perfect after that.
Okay, so do your laws currently for the CCB then require any, in making their determinations for they're determining whether somebody gets a permit or a license, correct? And so are they required to provide any public report or issuance of their reasons for denial, potentially for a permit or otherwise?
Yeah, I just want to make sure the vernacular is right. We talk about licensure, but actually what they're doing is giving the endorsement back to the state. So they're giving our endorsement to the state, who then would give the license based upon the recommendations of the taking into account the recommendations of the city. The CCB would issue a public resolution, which would be open to the public, to say these are the reasons we're granting it, or these are the reasons we're not granting it, and that would be forwarded to the state. So it's very important to make sure the CCB makes very clear why it's doing what it's doing, and that's why we're doing it via resolution.
Does the resolution requirement itself make it clear that they have to explain their justification, or is it? I just want to make sure it's explicit so that don't have issues with regard to people wondering why they may have been denied an application or a permit and so forth.
My recollection is the verbiage says the reasons for denial will be put forth in the resolution, but I will double check that. We certainly don't want we certainly want resolutions coming out of the CCB just saying approved or denied. That really doesn't no one any good, especially if you have to defend our decisions in court. So we make sure that it's clear why the CCB is doing what it's doing. But I'm pretty sure it says that already, but I will double check the verbiage on that.
And Nick, let me ask you this question before we move on, because I know we got other stuff to cover here. With us, with the CCB, we're following the ABC board, correct?
Right, we're using that structure as our
Okay.
process here, right?
So now with the structure of the ABC, I know you have to be Democrat, Republican. So will we apply that to the CCB?
We have not. That is
Okay.
required on the state statute for ACB. We took the three-party board, but we didn't add some of the extra requirements like the party affiliation. We did not add that to it.
Okay, and so just to be clear, even when it comes to the mobile, with Councilman Rolando's making that statement, so you said you can add that to make sure it's clear that we won't have no mobile delivery, whatever you want to call it.
Well, actually, delivery probably the one thing you would allow for mobile to do delivery, which would not allow is everything else. In terms of, I think what everybody's concerned about here is you don't want to have like a ice cream truck style or food truck style thing rolling in and serving cannabis, which is totally understandable. We'll explicitly put that in the ordinance in the appropriate location prior to Wednesday. That's not a problem. But like I mentioned, I just don't see how they would ever be able to get the approvals to operate.
I know, but you never know.
I understand the council's
This is
concern.
government, so you never know.
I understand.
This is government, you never know. We're trying to cover as much as possible. This is something we have to talk about more so than we imagine. Okay, so Rolando, you got one more question before we move on?
I've got, if I can, two questions.
Okay, because we have to move on. Go ahead.
Sure. Can CCB members be consulted pre-application? Or are they prohibited from having interactions with applicants?
Yeah, I think the intent is to make sure that whatever the applicants get within the four corners of the application process, I'll double check the ACB standards regarding that. Maybe we'll plug those in. But I think, Councilman, I think what you're getting at, your intent is to make sure the CCB is completely neutral when they review these applications or not. And we can certainly plug that in and make it explicit.
That'd be great. And then my last question, the talk about, there was a slide relating to public consumption being prohibited. So does that mean on a city sidewalk, if people are smoking marijuana, recreational adult use marijuana, is that prohibited on a sidewalk in front of any residential building or retail establishment?
Yes. No, the important thing to keep in mind is the state's Smoke-Free Air Act applies to cannabis generally. So anywhere that we're currently as a restaurant or a bar where you can't smoke a cigarette now, that would also apply to cannabis. What we also wanted to make sure we included was pedestrian malls, public sidewalks, public parks, and also included that for purposes of prohibitions of cannabis, like you described. So yes, the idea is, hey, I went to a retail establishment, I can lawfully obtain marijuana, I'm going to a street corner, I'm smoking it. That's not an appropriate location under our ordinance for a location as to where you can smoke it.
Okay.
Council President, can I just make one recommendation to Matt
Sure.
and the others? I'd like to recommend, I'm happy to set it up. I'm the chairman of the Municipal Alliance, which is about substance abuse prevention. I'd like to ask if you could do a presentation to those Municipal Alliance members so that they can kind of weigh in with their thoughts with you on that. Those are the substance abuse prevention providers throughout the city. They've got, I'm sure, a few things that they would like to say on the subject.
Okay.
Okay.
All right.
Thank
Thank you. Okay, Sean, we ready. So Matt, just send the presentation to Desiree so we can have a copy of it.
You got it.
Thank you. Come on, Sean. Thank you.
Okay. Item 3.3, City Ordinance 21-054 is an ordinance amending Chapter 254, Property Maintenance, and Chapter 160, Fees and Charges to require routine structural facade inspections for certain buildings within the city of Jersey City. Council members, this is a late item that we had to put on the agenda, and I'm going to turn it over to our business administrator to explain.
Yep, thank you, Sean. Thank you, Council. This was an item that was in the works. However, due to some complications implementing it into DocuSign, that's why it kind of looks as, I mean, sorry, not DocuSign, iCompass, which is why it's a late item. We do have the HEDC director, Director Meyer, and I believe Tanya on to discuss what this does. And of course, this is sort of a reaction to the events that we saw in Miami and some of the best practices we can implement for our building regulations. So I hand it over to Tanya, and then if she, I'm sorry, Anicia, and then we'll go from there.
Hi, City Council members. I am here with our construction code official, Ray Meyer, as well. This ordinance, as the BA had mentioned, was in direct response to what happened, the collapse of the building down in Surfside, Florida. What we decided to enact is ongoing inspections required for existing buildings here in the city. The ordinance has two parts to it. It has a requirement for structural inspections, and that pertains to buildings with higher than or above 6 stories. So basically building 7 stories and above. And then there are facade, the second part of it is the requirements for facade inspections. That law, that part of the ordinance is very much modeled on Local Law 11 in New York City, which requires facade inspections. And that pertains to all buildings also above 6 stories, so 7 stories or above, or if a building has a masonry facade, it would also require buildings 4, 5, and 6 stories. And we're here to answer any questions that you might have on the ordinance.
Questions? Go ahead.
I have a question. Go ahead.
Go ahead.
Okay, this is Councilman Navarro. Hi, Director Chiolone. And Ray, nice to see you both. Just reading this, it says it shall apply to all existing buildings or buildings constructed which are concrete buildings more than 6 stories in height. Is it possible there are buildings in excess of 6 stories that are not concrete buildings? Speaking more specifically about existing buildings.
Yes, buildings might be made of steel as opposed to reinforced concrete.
And why would they be exempted from this?
I'll turn that to Ray.
The steel buildings have a better chance of holding up to different conditions and stuff, and as opposed to concrete, which due to settlement and whatever the case may be, or just conditions out there, like spalling of the concrete and stuff like that that we see going on with a lot of buildings can create a lot of problems later on. So the steel buildings have a lot more durability and lasting.
What's the inspection schedule for the steel buildings?
There's currently no requirement for it. There, in general, the way that, so all of our inspection regulations and all of that are built on the building code, which is mandated at the state level, and they're typically they're focused on while a project or while a building is in construction. There are not a lot of parts of the code that require ongoing inspections, namely those, I mean, Ray can correct me if I'm wrong, but namely those are elevators and sprinklers. Is that correct, Ray?
The ongoing inspections that we deal with as far as inspections goes would be elevators, which is an annual cycle, and backflow preventers and swimming pools. So that's the only ongoing requirements that we have in the state for that this office handles.
So this ordinance adds in 2 more requirements on top of those. So there are not, in general, there are not ongoing requirements.
Ray,
Yes.
do you guys have enough personnel or with inspectors to start this?
Well, basically, we'll need, clerical staff to basically begin the process of the assessment, beginning the assessment process. And then the inspectors themselves would probably, we have to increase our inspectors by about two more inspectors to handle the requirements that we would have to follow up on.
Yeah, Ray and I had a conversation about this, trying to understand what the staffing needs would be, and we believe it's 1 administrative person and 2 inspectors to review reports and conduct follow-up inspections and potentially be available for court appearances in cases where people are not complying.
Ray, do we really have qualified people that know what will be going on or how to do this inspections? I mean,
I'm sure they're qualified. My concern is that, do you have enough, or the inspectors that you're talking about, Anicia, we're talking about new inspectors, correct?
Correct. That we believe it's 3 additional staffing, 3 additional staff needed for the Office of Construction Code. But just to clarify, the ordinance requires that the building owner hire licensed professional engineers or a licensed architect to conduct these inspections. That is standard across the industry where anything like this is required. They're not done in-house. What happens is they pay for licensed professional to conduct the inspection. The inspection reveals what the conditions are, and then when that report comes back, it talks about follow-ups, timelines, and can speak to things about, like, for example, whether it's just routine maintenance needed. Like, for example, if we're talking about like a brick facade, does it need repointing? Does it need something simple, or does it need something more extensive? And that's where the review comes in within the Construction Code Office, where we need inspectors to review what comes in to make sure the follow-up is happening when there's something more serious, or even that they're doing the ongoing maintenance.
And as far as training goes with the inspectors, I mean, the training is a continuing process in this office here. I mean, you're based upon, your licensing requirements is based upon 7 years experience in the field of working and stuff like that. Plus the guys go out with, other trained inspectors that have more seasoned experience and stuff like that. So in reviewing the reports and stuff, there will probably be senior members that will go out there and review the situation, and it'll be turned over to either the subcode or a construction official to basically go with those things there, because he's putting his signature on any notices of unsafe structures or imminent hazards. So it's out there. It's basically it's a start, and hopefully we can minimize a lot of stuff that goes on out in the field and conditions, for later on and in the future.
So let me ask a question. So inspections will be required like every 3 years, every 5 years?
So for the structural inspections, they're required every 10 years, but the first inspection will be required before the end of December 2022. We need time to kind of get this up and running and get people on a schedule. And for the facade inspections, they're required every 5 years. And what you do is part of the requirement is that they compare to the prior report, especially on things like a masonry facade. You want to see where the masonry may have shifted or changed in that time period. And for that ordinance, the amount of buildings that would be covered under that are much larger. It's a much larger amount. So we've given until December of 2023 to have the first inspection, but we're going to work on a rollout process so that we don't want all the buildings getting it at the same time. There are not enough licensed professionals to do them all at the exact same time. You need to stagger it. So from an administrative side, we're going to work on that, getting them rolled out.
And so we have inventory pretty much of the buildings in this city, correct?
So what we can do is, what we have are the tax records. I mean, that's always our main data source. Right. We did pull the tax records. The tax records, sometimes they give us that indication and sometimes they don't. But for the facades, we like for 4, 5, and 6 stories, we have a pretty good sense of how many buildings we feel have a masonry facade based on the coding categories. We think that that's slightly over 1,000. And for the buildings that are 7 stories or above that are made from reinforced concrete, the number is not that great. The data shows us 37. Ray and I are looking at the total number. There's 176 buildings that fall into that category. We think it's probably closer to about 80 of them. The tax data doesn't always give us that, that level of data that we would like. But the first step for the structural side would be a mailing to those 176 buildings to have them certify the structural system. And then once we know that, we would have whatever that number is, say it's around 80, we would build a whole program around those 80 buildings.
Okay.
And would Diner Division play a part in this? Because those buildings have to be registered too, some of them, right?
Absolutely. They're all
Right.
supposed to be registered. I mean,
Right.
there's an assumption. This doesn't speak to whether or not they're rental properties, but
Right,
most likely they are. We can cross-check that with her office. Yes, absolutely.
Yeah, that's what I was thinking of.
Though her
Okay.
office though wouldn't, the registration she gets back won't indicate, the type of structural system or facade
Right.
material. But they would give an indication that whether they registered or not. We certainly can cross-check it to see if they registered. If not, we can follow up on that side.
Okay, so now if this passed, then you need 3 new staff members, correct?
Correct.
2 inspectors for really
And one
reviewing
administrator.
and 1 administrator. So
Right.
as soon as we pass this, then we would have to hire 3 people, right? Because we in budget here, and so I'm just
Yeah.
trying to.
Yes.
Yes.
We do understand that. This all came up very quickly, obviously was not anticipated when we put in our budget back in the fall. So we do recognize there is a budget implication. Luckily, the construction code office brings in plenty of revenue that should be able to cover the costs of these inspectors or of this staff. But we would not wait to have a new person hired to get going on this. We certainly would start the administrative aspects right away. But yes, to properly administer it, we do believe there's additional staff required.
Okay. All right. Anyone else?
Yeah, this is Councilman Solomon. Just to clarify, what's the penalty if a building doesn't submit their inspection reports on time?
I believe that's covered on the penalties. Shall be subject to penalties, which
Yeah, it's the standard city penalties that are up to $2,000 a day. We would have to come up with, a schedule of how we determine the exact number, probably based on the severity of the seriousness of it. But it ties back to the same ordinance and the same aspect of the ordinance that is for all penalties and violations.
Got it. And then, I just sort of thinking through when a report comes back that says that there are repairs that need to be done, as I read the ordinance, and correct me if I'm wrong, it sort of says that they need to immediately undertake the measures, but immediately isn't sort of defined. And then it sounds like our kind of approach is if they don't actually do the recommendations, at some point the construction code official can declare the building uninhabitable. I just want to sort of think through, how do we really ensure that these buildings are actually going to do the repairs necessary based on the ordinance?
there's a 2-step process. One would be is repairs, which would be covered under code enforcement under the housing code, under property maintenance of 254. The other thing would be is that if it deems itself to be unsafe or imminent, okay, the next step for my process would be is working with the courts to try to get the courts to bring about compliance. And also the final step is basically taking the necessary safeguards that would be required to be done, such as vacating the building if need be.
Also, the ordinance specifically asks for the report to outline the recommendation by the professional for the timeline for repair. And it says that it would be done in conjunction with the construction code official, meaning the report will say what the timeline is. If the construction code official disagrees with that timeline, if it's like overly long or, there's something in there they disagree with, they can have that back and forth, and the report can be not, it can be rejected until it gets into compliance. So there is a little bit of that. We are looking to those professionals to help us, assign what is a reasonable time frame. I mean, we recognize these things often cannot be repaired immediately. There's, funding aspects to it. It takes a little while to put together documents and bid the job out. I mean, there's, reasonable timelines, but we've asked for that in the actual report. And then that report gets submitted to the construction code official within 30 days of that inspection. They're able to review it, and then they go from there and they set a timeline. So the construction code official then would have in his system the timeline it's anticipated to be completed and can follow up to make sure the work has, commenced, how the job is going. So that's where the additional staff really comes in, because we would need to do those touch points to make sure it's moving forward.
Can the construction code official amend the timeline in essence? So if that report comes in and says, we think you need to do these facade repairs in a year, and our inspectors look at it and say, no, we actually think this is more serious, you've got to do it in 6 months. Do they have that formal power to say you guys need to do it more quickly than what you're, because the one thing is the condo boards are hiring their own inspectors, which maybe creates some incentive for that inspector to, maybe give the condo boards a little more leniency.
Well, it would depend on the severity of the report. I mean, if I'm faced with, bricks that are basically held together by gravity and stuff like that. All right, so let's turn around and look at netting. We'd look at scaffolding and stuff like that. So that's why these reports, will cause an inspection to be made based upon the report, and then we'll handle the thing accordingly and discuss with the design professional. Okay, what are we looking at here as far as the time frame goes, and what can we do to stabilize things and safeguard it so that we don't have an incident occurring where a parapet wall comes down, crashing out onto the sidewalk and stuff.
But I guess that's right. Just to clarify, what you're saying is you do have that power. I just want to make it clear that you guys, if you don't think the timeline laid out in the consultant's report is appropriate, that you have the ability to basically overrule them and say you have to do this more quickly.
Yes.
Okay.
Yeah, the way it's written in the ordinance is all repairs must be made pursuant to the recommendations and timeline set forth in the structural inspection report. Same thing for the facade, and in conjunction with the recommendations of the construction code official. So the construction code official has to agree to that timeline.
Okay, great.
It gives the city a little bit more teeth in the ordinance, because basically we can't let things drag on forever, so we have that ability to react to it under state statute too.
Okay, someone else?
Yes, Councilman LeVar here. With regard to repairs, it indicates here that if repairs are not made, that you'll have the power to shut down the building. That poses a threat to the safety and welfare of the residents who are occupying the building, which I'm fine with. But my question or concern is who will be responsible for the relocation and their costs for relocation for those potential residents? I think I would want to build something in here that would require particularly if it's a rental, the property owner who may have neglected or has the structural too, to require them to pick that up and to pick up those costs for relocation.
I'm not too sure, but didn't we do a relocation ordinance? Didn't we do one of those?
We did. I'm not sure what the details were there, but I don't know if it requires them to pick up the costs. Does it do that? If somebody can research.
I have to check to find out what it is, but I thought we did a relocation ordinance and stuff, if I remember correctly.
We did, yeah, and we can look at into what exactly the language is and how it would apply to this framework that we're putting in place. But generally though, a tenant who a renter who lost the access to their apartment because it's been found structurally unsound would have remedies against their landlord in landlord-tenant court for breach of the lease. A resident of a condominium building, for instance, may have recourse against the association, or if there's a maintenance company that failed to perform their obligations. That doesn't necessarily answer the 24-hour question of where will the roof over my head be tonight, but that's why we can look into the relocation question.
Yeah, my understanding is there's an ability to put a lien on the management if they don't, so in order that they do it. We will check though with the other ordinance to make sure it's coordinated, but it wouldn't be any different than if there was an imminent hazard that Ray had to declare now, without this ordinance. But we can check those responsibilities.
Sure, if you could report back on that. And my concern though is that if the options are left to legal remedies for the tenants, particularly if it's a rent controlled building or something like that, and people have a certain income, they're not going to be able to avail of legal remedies. They won't have the financial wherewithal to do that. So we should be able to impose it upon the landlords and the owners there to ensure that they get them into immediate housing situation. Look, I don't know that it would happen overnight, but I've heard the stories of like a building being shut down and then tenants kind of scrambling to find housing for themselves. And then the other thing I would add there is that housing is the cost of housing is high here in Jersey City. So if they were in a rent controlled facility of building, and then they're out there trying to find something else, they'll need something immediate. And so, if they're finding something that's more than what they would normally pay for rent control building, who would assume that cost, that difference in the short term at the very least, so while they continue their search for more suitable and affordable housing, which would probably be unlikely, frankly, in Jersey. But I would say that onus should fall back on the owner again, particularly in those types of situations.
Yeah, I believe that's covered in the other ordinance, but we will check, as we said. But also, I do think that an ordinance like this will help minimize those situations going forward, right? Because typically we wouldn't know about a situation until it was so serious that we did have to declare imminent hazard and remove people from the building. But this should give us an insight into what's happening in the buildings and catch stuff much earlier. And I think it should minimize that situation. Not to say that it wouldn't maybe bring something forward that was more hidden. But I think declaring people needing to empty a building, that type of a decision by the construction code official is drastic, and they definitely take it very seriously and review it only in the most serious of cases. But we would work as much as possible to make sure they can make those repairs along the way so that we don't get to that stage.
Okay.
My last comment, Council President, just on the fees. The basis of $100 per structural inspection report or $100 per facade inspection report, those seem potentially very low to me. If you have a issue where there's a problem and you have to have ongoing inspections to ensure that they're continuing their work and that they're going to be complying, I would think the cost to the city would be much more in that regard. But I'd ask you to take a second look at that and to see if those fees should be increased to make it, it's only every 10 or 5 years. And if we're going to do this and make sure that we follow through on it and get it right, then we should give people the resources they need to make sure it gets done.
Yeah, we certainly can do that. I think there was a conscious effort on our part to not present overly financially burden some of the smaller building owners. And so there were, we were just, I think maybe for the structural inspections, those are more larger buildings. But the facade inspections could be a 4-story building. It could be like a 3-family that someone owns. And I think we recognize there's costs associated in performing the inspections. You have to pay the licensed architect or engineer to do them. You have to make the repairs. So we were trying to incentivize them to actually do that stuff, put the money into the repairs of the building, hiring the professionals. So we kept the fees purposely low, but we're not against raising them. I just wanted you to understand the background to that.
Sure. Is there some way to condition it? Like if somebody's got a building that passes with flying colors, certainly don't want to overburden them, particularly if they're kind of a smaller building, as you said, or have fewer resources, financial resources. But if they're, if there's an ongoing problem with the building, is there some way to structure some fees so that we're covering our fees over time for inspections in order to make sure that people are going back and and checking on the continued progress of that compliance.
Yeah, we can talk to the law department, we can structure that. I know we did have a lot of discussions about that going into the ordinance.
Yeah, we can work.
Okay. All right.
Thank you.
Okay, Sean.
Thank you.
Thank you.
Thank you.
Okay, on to our second reading ordinances. Item 4.1, City Ordinance 21-034 is an ordinance accepting from Maple Street Row LLC a dedication of certain newly constructed rights-of-way that extend Maple Street and Garabin Street. Any questions or comments on this ordinance? Okay. Item 4.2, City Ordinance 21-049, a franchise ordinance granting permission to 144 First Street Holdings LLC for the installation of a 5-foot diameter cover manhole along an oversized tree pit to house a controlled structure for sanitary sewer detention system, 2 house trap cleanout caps and decorative planters along Provost Street at Block 11502, Lot 6, also known as 144 First Street, encroaching into the right-of-way.
This
Any
is Council. Yeah, this is Council. I just want to let I haven't heard back from the developer here that they've gotten the okay from the neighborhood association. So I am waiting for that before Wednesday. But if I don't get it before the meeting on Wednesday, I'd ask that we, we can do public comment and then just table if we don't get the approval on the neighborhood association.
Okay.
All right.
Okay.
All right. Next, item 4.3, City Ordinance 21-050. It's a bond ordinance of the City of Jersey City and the County of Hudson, New Jersey, providing for the acquisition, installation, and construction of various items of energy, conservation, equipment, and improvements appropriating an amount not exceeding $9 million, therefore, and authorizing the issuance of not to exceed $8,550,000 general obligation bonds or notes of the City of Jersey City for financing a portion of a cost thereof. Any questions or comments on this ordinance? Okay, second reading ordinance, item 4.4, City Ordinance 21-051, a refunding bond ordinance of the City of Jersey City and the County of Hudson, New Jersey, providing for the acquisition, installation, and construction of various items of energy, conservation equipment, and improvements in connection with energy savings improvement program of the city, appropriating an amount not exceeding $7,700,000, therefore, and authorizing the issuance of not to exceed $7,700,000 general obligation refunding bonds or notes of the City of Jersey City for financing all or a portion of the cost thereof. Any questions or comments on either bond ordinance? Just a point of information, bond counsel has contacted us with regard to them meeting with the local finance board. So we're not able to adopt these bond ordinances at the meeting on Wednesday. So I think the procedure is going to be to hold a public hearing on both bond ordinances and then table after the close of the public hearing until the bond counsel can meet with the local finance board. Is that correct, Business Administrator?
Yeah, Sean, thank you for clarifying that. Council, the state agency was not able to hold their monthly meeting this month due to a quorum issue. So we're going to have to table after the second reading. After the public hearing, and wait for the state to hold their meeting prior to our continued action.
Any questions on that? Thank you, John. Okay, next up on the agenda, we will hold a public hearing on the calendar year 2021 municipal budget. And right after the public hearing on the municipal budget, we'll have our regular request for hearing for members of the public. Then on to our petitions and communications, items 6.1 through 6.10. Any questions or comments?
Sorry, just going back a quick second, the public hearing on the budget.
Yeah.
That's on the mayor's introduced budget. That's right. We're going to do a second public hearing on an amended budget.
So John, do you want to answer that?
Yeah, that's a great question, Councilman. Yes, so this is a request for a public hearing for members of the public on the introduced budget that occurs 28 days after the introduction of the budget to give the community time to review and comment on the introduced. Followed up in a following meeting, we'll have a budget amendment, and then there'll be another public hearing on the items that will be amended.
Great, thank you.
So we'll introduce a resolution introducing the amendments, and then at that next meeting, we'll have a public hearing, and that's when yours truly has to read line by line all of the amendments, if you remember last year.
Got it.
Okay, great. Thanks,
Can I
John.
just ask on that, is there a date scheduled for this amended, for the amendments, or are we looking at the August meeting, or to the council president or the administration?
Yeah, Councilman, we're looking forward to the August meeting. Obviously, we're just wrapping up our meetings. We still have some to go with the council, and then we'll have a compiled draft agenda. Draft amendment in which we'll share with the council, and hopefully we have something set forth to introduce at the August meeting.
Correct.
So the final adoption would be at an August meeting? Is that what you're looking at?
So the introduced would be at the August meeting, and then we would either have a special meeting, or the following meeting it would be second public hearing and final adoption.
So there would be a final adoption after the August meeting? Is that what we're looking at?
Correct. So
Going into-
correct, because we have to introduce an amendment and then act on it after it's advertised.
I see. Okay. Then when is the public hearing on the revenues? When are we going to do that? Do we have a date?
I believe we scheduled it for tomorrow, if I'm correct.
Oh, really?
I'm sorry, it's actually Thursday, John.
Thursday. Okay, sorry.
Okay. And what time is that?
I believe it's 10 a.m.
Great.
I'll get back to you, but I'm pretty sure it's 10 a.m. on Thursday.
Okay.
Yes.
And what's that? Sorry, Council President, who's
It's
chairing that?
9:30. It's 9:30.
Okay.
Well, that's what the invite said,
You and
right, Council
I.
President?
Excuse me?
Is that what the
I couldn't hear you.
invitation said?
Yeah,
9:30?
yeah.
Yeah, so I mean, but I think it's actually scheduled for 10 a.m. We just like to get
Yeah,
everybody on at
right.
9:30.
Right
Everything's
on,
working properly.
9:30, yeah.
Okay, thank you. Councilperson LeVar, you had another question?
I was just asking if, so I think the Council President said that she and I are chairing that, co-chairing that?
Yeah,
Okay,
yeah.
great. I just wanted to, so John, I'll probably have, and Council President, I'll have some questions, I guess, on the revenue section to just discuss with you before the actual meeting itself. I have no further questions on the budget.
Okay, all right. Officer Communications, items 7.1 through 7.4. Any questions or comments?
I have a comment
And then
on
we have our
petitions and communications. Sorry. 6.1, the petition for the senior swim. So has that been answered, or have we, I think that petition was calling for like set hours for seniors to swim. Is that correct? Anyone familiar with that?
The petition was sent to all the council members when it was received by this office. I'm not sure on the other end whether it was answered or not.
John is,
Councilman, I'll make sure we get Director McLaughlin to confirm. I know I did see some
Right.
emails back and forth, but I'll make sure we confirmed it.
and then my
Thanks,
only
John.
comment on that would be that if we're looking to establish what I think is a good idea, per se, to do set senior hours for swimming, that we look at all the pools for that purpose,
Mhm.
make that available for seniors across the city.
Yeah, I think the recreation director mentioned something like that on her budget presentation.
Yes, Council President, we'll just get it in writing.
Yeah, she mentioned that. Okay,
I have no
all
further.
right, Sean.
Alrighty. Report of directors, items 8.1 through 8.6. Any questions or comments? Okay, we'll have our claims, which is attached to the agenda, and then on to our resolutions. Item 10.1, City Resolution 21-513 is a resolution of the Municipal Council of the City of Jersey City condemning and combating Islamophobia in Jersey City. Item 10.2, City Resolution 21-514 is a resolution authorizing the renewal of a contract with Liberty Humane Society for animal control services for the City of Jersey City. Item 10.3, City Resolution 21-515 is a resolution of the Municipal Council of the City of Jersey City authorizing the award of a contract with Liberty Humane Society to provide sheltering services for domestic pets pursuant to NJSA 40:48-5.1. Item 10.4, City Resolution 21.
Nobody wants to talk. Okay, that's fine. Perfect. I'll just go.
Item 20, Resolution 21-516 is a resolution of the Municipal Council of the City of Jersey City authorizing the execution of a mortgage discharge affecting the property known as 17 Boland Street, Jersey City, New Jersey 07306. Item 10.5, City Resolution 21-517 is a resolution of the Municipal Council of the City of Jersey City authorizing the execution of a discharge of mortgage affecting the property known as 1209 Summit Avenue, Unit 405, Jersey City, New Jersey. Item 10.6, Resolution 21-518 is a resolution ratifying the extension of an emergency contract award to Red Rabbit LLC to continue to provide prepared meals to food insecure Jersey City residents as part of the city's ongoing response to the coronavirus pandemic.
Could I just ask about this? Over the weekend, there was a report in the media about food as part of our food program that there was some spoiled foods and delivery issues and so forth related to that. Director Flanagan, can you speak to that? And let me just also add that ran into somebody.
Yes, I spoke about it at the budget hearing. There was no food.
I'm sorry, if I can just complete my comments. And then I also, over the weekend, ran into a resident of Country Village, and I was going to send it over to you today. I'll send it over after this meeting. I have pictures of, and I don't know if they come from our program or something else, but at Thomas McGovern Park, there was a lot of food and milk and other things that were left out in the open there on Thursday, disposed of out in the park at the garbage public trash cans over there. So I'll send it over to you as well. With that being said,
Thomas McGovern Park?
Thomas McGovern Park in Country Village.
Okay. So for those that don't understand how the program works, the food service program for summer, which doesn't have anything to do with the contract that we just are presenting, except for the same vendor, is that every agency across the city that would like to serve summer meals applies to the Department of Health and Human Services, signs an MOU, and goes through official training on temperature checks, food safety, serve safe class, and then a monitoring course. The monitoring is to make sure that when a child, because we get paid for every meal that is eaten, right? So like, let me make that very clear, because people like to order sometimes, and for every meal that we order, if it's not tracked and assigned to the one individual that requested it, it is not paid for by the grant. So there's monitoring at every site, managed directly by the either nonprofit entity or summer meals program. So the actual serving of the food is not done by HHS. It is done by any agency that takes on that responsibility to feed someone. So yes, if garbage is an issue, I want to make sure that that is monitored and that agency understands that food that they are delivered should not be left out, one, and two, because it all must be served within a certain period of time, which for food safety purposes, nothing can be left out for more than 4 hours total, but based on the temperature, which every location has thermometers to check temperatures on arrival. So every arrival of every food source comes, and the monitor at that local agency is responsible for checking. That being said, on Tuesday, there was a car breakdown for one of the delivery cars. The Red Rabbit tried to fix the situation by renting whatever car they were able to rent. And in the travel, the food that left the location arrived too hot to serve and was not served to any individual. And that was because those agencies, right, took the temperatures as that was their responsibility to do and sent back the food, which is the appropriate thing to do. When we got the calls from many of those locations that took temperatures and that the food was not at the right temperature, we ordered food from any of the restaurants that were able to accommodate us through the New Jersey EDA grant that we have, Sustain and Serve. Due to the number of meals, we could not accommodate every meal, and only 4 of the 6 locations that were impacted were able to get lunch. Since then,
Okay.
the 52 sites, right? And so this is why I think I've been listening this whole time on, people making new rules for the health department and, not new staffing, right? So if, like a lot of things, right, if there were more restaurants open during that time that could have the capacity to make 100 meals, I could have ordered those 100 meals. But we did call all the restaurants that were still open on the NJEDA grant, and they did not have the capacity. This is actually why we applied for the 3rd year in a row for the EPA, USDA, local food, local places, technical assistance, so that we don't have to rely on vendors for our entire food source, and that we should have an appropriate value food chain in our community. This year we won that grant. We created a steering committee. We passed that resolution of accepting that grant at the last council meeting. We sought to engage a vocational school, local vendors, to make sure that in the future, hopefully Jersey City's making this food, hiring local people, and the food doesn't have to travel too far, and that doesn't occur again. As far as garbage, I will check to see which exact agency is responsible for the park on Thursday and make sure that is not an issue moving forward.
Thank you. Thank you, Director.
Stacey.
So can I just get some clarity
You
to a
said that
specific
all the
question?
sites didn't get food, right?
2 of the 6 sites did not get lunch that day. They were provided breakfast. It was because the restaurants we called couldn't make a delivery. We talked to the Department of Recreation and Youth Development, and we have now a backup plan. This was their first day of camp, for, alternative shelf-stable items to have on site in case food is, not of the quality when it is delivered.
So how do we determine which sites got food and which didn't, or
I
was
have
it
a
based on
list.
the
I have a
delivery?
list. No, I have a list of the sites where that vehicle traveled and the food that was temperature checked and returned. And the 2 sites, Recreation manages and will be giving me the names of all the families that were impacted by that day. So I'm just waiting for that list to follow up directly, but all families received a follow-up from Red Rabbit. Red Rabbit visited all sites. They were trying to complete the 52 site visits over the last week to just improve service delivery.
Hi, this is Councilman Lavarro, Director.
Yeah.
So just if you just speak directly to the question that I'm asking, which is that
Yeah.
there is, so from my understanding, there's 2 of the 52 sites were not served food because of the, for 1 day.
Correct.
And you'll provide us that list of information about which sites those were.
Yes.
But as far as like the city's own city-run campsites, there was no, it's your assertion testimony that that no spoiled foods were served to any of the students. Spoiled food or drinks or refreshments were served to any of those students.
Correct. There was no spoiled food, no refreshments served to any of those at the city sites. I am not at those sites. Those sites are managed by Recreation and Youth Development. They were trained. I spoke all day long on the phone with the director of the campsites, and he stated none of that food was served. All that food was returned, and my staff called restaurants and had food deliveries made in lieu of that food.
Great. And then at the partner sites that are not city run, can you make the same assertion, or is it not really clear at this point as to what they may have done?
So every site is required when they receive food. This happens, by the way, not just for summer meals. This happens at every USDA regulated food site. This is why it's really important when we have all these federal regulations and we start creating policy that we understand. Like I am tagged in on a lot of important policy roles, and if an agency did not take the temperatures when they received the food and they did not tell me that, right, I'm not clear, because it's the agency's responsibility every day when they receive the food to take the temperature. If the temperature is not at the temperature we train them on, aligned with the certificate that we also trained them on, there's 2 trainings. We provided a training about the monitoring of the food and the individuals, and then a serve safe training where the individuals must receive a certification from Serve Safe to be able to accept food for summer meals. If they did not tell us that they took the temperature, then I would not know accurately if that food was taken. I do know exactly the locations where the 1 truck that is not refrigerated went. And I do know the ones that those visits, some may have received the food earlier and the food was at the right temperature, because that's what we understand from the data that they have reported to us. So that's self-reported from the agency itself.
Right. So those agencies did not serve, to your knowledge, any spoiled foods or?
Correct. To my knowledge, the agencies that received food took the temperatures. We know the ones that took temperatures and the temperatures were off, they did not receive the food. They returned the food. The food came out, they took the temperature, they return it. That is our daily practice. We do that with our senior meals. Senior meals arrive hot, and they need to stay at that heat when it arrives, and therefore we take those temperatures as well.
Thank you, Director.
Thank you.
Okay, Sean.
Okay, next item, 10.7, City Resolution 21-519 is a resolution rejecting the sole bid received by the City of Jersey City on May 25th, 2021 for a contract known as the Persian Field Natatorium re-roofing project number 2021-002.
Thank you, Council. This was a bid that we went out to fix the roof on Persian Field facility. And as our cost estimates, we were hoping to get competitive bids that were similarly attractive to that $600,000 number. Unfortunately, one bid came in which exceeded that amount substantially. So we're going to do some smaller repairs on the facility and then rebid the other portions of the work to hopefully as an aggregate bring it back to that $600,000 number. Mr. Weller's here as well if there's any particular questions.
So, Ryan, is that, was that sole bid, how many roofers, was that done via bid sync? Is that how that's done?
Yes, it was done publicly, bid sync.
And do we have any idea of how many roofers are in the, or businesses that would provide this service are in that bid sync system?
Actually, not a lot. This is borderline very proprietary, that roof system that's over that pool. It's very unique because of the ability for it to open the way it does. There's not a lot of competition.
I see. So it's a specialized type roofing?
It is, yes. And there's a very long lead item on it too.
Okay, thank you.
Sure.
And Councilman, just for a little further clarity, this project includes a motor attached to the roof. So not every roofing company feels comfortable or may particularly have the mechanics to facilitate the changes on that.
Noted, thank you.
Okay, Sean.
Okay. Next is a resolution, item 10.8, City Resolution 21-520 is a resolution authorizing a license agreement with Jersey City Redevelopment Agency for the use of Block 11401, Lot 13, more commonly known as 174 Newark Avenue, allowing the city to continue use of the property for parking.
Let me ask a question. I thought redevelopment moved to MLK at the Jackson Hub. They did, right? So we still paying for parking on Newark, whatever?
No, this is an ordinance or a resolution that this is the parking lot next to the Palace Drugs on Newark Avenue. And owned by the JCRA. So it's just saying that it's maintained as public parking.
Okay, all
so
right.
It's not parking for our city employees, it's just public.
Was there a study for this, or was there a study to look into determining if it's an area or something to that effect? I forget exactly.
We established it as an area in need of, I think, rehabilitation, but we have not written a redevelopment plan for that lot.
And is someone here to speak to the time frame on that? Just like what?
No, I mean, this is simply an agreement to allow it to extend as a parking lot. This was we did the study on this like 2 years ago, and it's been installed. I've been looking into it, so I'm happy to kind of provide a little bit more information in the coming weeks on where I think this thing stands. But this agreement that's before us is purely about saying you can keep using this as a public parking lot.
Noted. Okay. If I may, just I'm just reminded of the other parking lot in Newark Avenue, further west, going towards Five Corners or past Five Corners. And I've expressed in the past, and nothing's been done to the business administrator, the JCRA, to the council people in the JCRA. That parking lot is a wreck. It's I've driven through there not too long ago recently. It's got huge craters in there. Repairs need to be made. I know that the project fell through there for the developer, and I guess we're looking, the city is looking into other options, but someone needs to do the repairs there because it's not a good parking lot. It's really in bad shape. Huge craters.
Okay. Okay.
Alrighty. Item 10.9, City Resolution 21-521 is a resolution authorizing the City of Jersey City's Office of Historical Preservation to apply for and accept the award from the New Jersey Historic Trust 2021 Capital Preservation Grant Award. Item 10.10, Resolution 21-522 is a resolution authorizing the City of Jersey City's Office of Historical Preservation to apply for and accept the award from the New Jersey's Historic Trust 2021 Historic Site Management Grant Award. Item 10.11, Resolution 21-523, resolution recognizing Juan Cartagena on the occasion of his retirement.
Councilman Rivera, I just want to ask, will you be presenting this to Mr. Cartagena at the meeting? Or was that done already?
I'm sorry, no, that's correct. We're going to be presenting it to him on Wednesday.
That's great. All right.
Item 10.12, Resolution 21-524 is a resolution ratifying an agreement with Robert Santilli Consulting for providing maintenance and support services for the police department's existing software applications created by Robert Santilli Consulting without public bidding.
Can someone just provide us which applications that is?
Is somebody here to explain this?
Yeah, I got some information for you, Council, and if we need any additional, we'll make sure we get that. But Mr. Santelli provides the scheduling and overtime pay period information that, because they're not on the same platform as the regular city employees, the public safety enforcement agents. So this schedule allows for the continuation of the overtime services, and then it transfers that overtime information into our payroll system so that we could have a seamless transition of the costs that we owe to the employees. This contract does expire December 31st of this year, and with our new payroll system that will be in effect, this particular support service will no longer be needed moving forward. It's just to get us to the end of the year as a patch. It's it's a resource that we've been using for 10+ years now.
So this service, so that software will be discontinued and they'll be working on the same platform as everyone else?
That's correct, Councilman. We've considered the services that this individual performs, or this entity performs, and we created a patch in the new system that will allow us to do it internally.
So just so I understand, so they will still use that system. It sounds to me like they're going to still continue using the Santilli system to record their overtime and what was it?
Yeah, the scheduling, the overtime payments and the scheduling of overtime, Councilman.
And the data will just transfer over to our payroll system, but they're still utilizing this system.
Correct.
I see. And does this include off-duty work as well?
I'll have to confirm that, Councilman. I believe that there's a separate vendor for that, but I'll double check.
Thank you.
Yes.
Okay, Sean.
Alrighty, item 10.13, resolution 21-525 is a resolution authorizing the payment of a claim submitted by Tomahawk Defense LLC for providing sustainment training for ESU to the Department of Public Safety Police. I'm sorry.
Thank you, Sean. This is a claim that was presented to the city for payment. in November of 2020, there was an exercise performed, 4-day training system for ESU in cooperation with our Office of Emergency Management for ongoing continuous training of their specialty training, including hostage situations and various serious events. And this payment is to pay that claim that was for the services provided in November.
So what type of, you said for hostage situations, is that?
Yeah, and various ESU situations that occur, with our area in the metro, being in the metropolitan area, they always prepare for large scale events as well.
Because it just says it's sustainment training. Not sure what that means, but.
I'll ask for the definition of the exact services that were provided.
What's that, sir?
I'll make sure that we have a list of the exact services that were provided in that training.
Thank you.
Yes.
Okay. All right, Sean.
Hold on one second, sorry.
Oh, go ahead.
BA, can you speak to why this wasn't presented to the council in October of 2020 for us to approve?
That's a good question, Councilman. I'll ask for a memo on that. Typically, it should have been done in that fashion. Not necessarily sure how this happened. I know, the ability to provide services were changed significantly in the state of the emergency, but this is kind of an ongoing service that we've been looking at, and I'll ask for a clarification on that.
Okay, great, thank you.
Okay, item 10.14, resolution 21-526 is a resolution authorizing an agreement with Fisher Telecom, Inc. for providing maintenance and support services for the Department of Public Safety, Avia phone system without public bidding.
What's this? What is this? Is somebody here? Because
Yep, Councilwoman, this is for our phone systems that we have at our communication center at Bishop Street. They're on a separate programming than the city, so this is their own separate annual cost.
okay. Like, they get enough communication.
Item 10.15, resolution 21-527 is a resolution authorizing a change order for a contract with Adamo Brothers Construction, Inc. for the Boyd McGinnis Park Shade Structure Project number 2019-041 for the Department of Administration Division of Architecture. Any questions or comments? Okay. Item 10.16, resolution 21-528 is a resolution of the Municipal Council of the City of Jersey City authorizing the city to enter into a cost reimbursement agreement with North New Jersey Transportation Planning Authority and New Jersey Institute of Technology, which will enable Jersey City to receive funding for the future task orders.
So is this the same funding that would normally support Barca's position?
Do you want me to jump in, John?
Yes, Barker, thank you.
Okay, hi, Councilman. Yes, this is the funding that we receive annually from the NJTPA to fund the transportation planner position. In the past, when I was within the planning division, it did fund my position. Now we have a transportation planner in planning currently, Elias, so it covers his salary, and there's some additional funds to cover additional staff members. It also helps pay for conferences and other supplies that the planners need whenever they go to the APA conference or other things related to transportation.
Perfect, thank you.
Thank you.
Okay. Item 10.17, resolution 21-529. It's a resolution authorizing the public sale of 2 motor vehicles, 2 dump trucks, 1 street sweeper, one wood chipper, and one salt spreader no longer needed for public use through publicsurplus.com public online auction. Item 10.18, Resolution 21-530 is a resolution authorizing an award of a contract to Convergent Technologies LLC for security maintenance of metal detectors and scanners at various city locations for the Department of Public Works Division of Building, Streets, and Maintenance through the Sourcewell Purchasing Cooperative.
Is this a new contract?
Councilman, I believe this is a renewal of a continuous project that we have off a co-op with the state. The initial encumbrance here is for to update some of our software, particularly with the side entrance now being open in City Hall for as a employee entrance. So we just wanted to make sure we had the contract in place prior to purchasing any additional needs.
We've had the contract in place previously. Is that
correct?
With the
Correct.
vendor? Okay.
Okay.
Alrighty, item 10.19, Resolution 21-531 is a resolution authorizing the amendment of a contract with Smart City Media LLC regarding the provision of public information kiosks throughout the city of Jersey City.
These are the kiosks that are out here right in front of City Hall and the same kiosk, right?
Yes, correct, Councilman. It's the same company.
So this agreement that we have with them, contract, is there like, I forget if there was any sort of profit sharing or revenue sharing involved in this?
Yes, Councilman. So there's a 20% cost share. When we initially entered into the agreement, we believed that cost share would be approximately, that the total would be around $600,000 to $700,000, and that the cost share would be 20% of that, which would be roughly $100,000 to $120,000 for the city. Their actual numbers have been significantly drastically cut due to the lack of entities either being open or being able to support some of their continued commercial needs. So that number was drastically reduced to less than 50,000 for last year as a net. And they're hoping to look at a recovery period over 21 and 22, and then being more operable back in 2023.
So you say cost share, meaning we're spending, or was it I thought it was revenue sharing.
That's the revenue share. Sorry, revenue share, not cost share. I'm sorry, Councilman.
Okay. So we get 20% of the 50,000, is that?
Correct, correct.
Okay, item 10.20, Resolution 21-532 is a resolution ratifying a contract to Royal Printing Service for printing official election machine and sample ballots for the primary election on June 8th, 2021. Item 10.21, Resolution 21-533 is a resolution authorizing the execution of an agreement between Newport Center LLC and the City of Jersey City to enable access through the mall at 8th Street and Marin Boulevard, 9th Street and Marin Boulevard, and Washington Boulevard. Item 10.22, Resolution 21-534 is a resolution authorizing the award of a contract to Turnout Fire and Safety, Inc. for the public safety uniform to supply and deliver for the Department of Public Safety, Division of Communications and Technology. Item 10.23, Resolution 21-535 is a resolution of the Municipal Council of the City of Jersey City approving Jersey City's fiscal year 2021 annual application action plan and authorizing the submission to the United States Department of Housing and Urban Development.
So I didn't get to meet with Director Gandula regarding this. Is she available here for questions?
I'm here.
Hi.
Hi, Rolando.
So can we just schedule, I apologize, I know you've been reaching out. We schedule something pretty quickly and just bring me up to speed.
Yeah, I'll have Carrie reach out again. And we'll
Great.
get it on the calendar. Yep.
I won't take up your time here. Thank you.
Okay.
Okay, item 10.24, resolution 21-536 is a resolution authorizing the payment of a claim submitted by Verizon of New Jersey, Inc. for voice communication services for the Department of Administration, Division of Information Technology. Item 10.25, resolution 21-537 is a resolution authorizing the settlement of action entitled Tyrone Brown versus the Jersey City Fire Department versus 21 Centrally Rail Corp.
Yeah, I distributed the memo this morning. It should be, if you don't have a copy of it yet, it should be in your mailbox at City Hall. If you have any questions on this, please feel free to reach out.
Thank you, Peter. Item 10.26, resolution 21-538 is a resolution of the Municipal Council of the City of Jersey City authorizing program contracts under the Community Services Block Grant, COVID-19 CARES Act funding for program year April 1st, 2020 through September 30th, 2022. Item 10.27, resolution 21-539 is a resolution of the Municipal Council of the City of Jersey City supporting the purchase and sale agreement between the Jersey City Redevelopment Agency and Hudson County Community College for the acquisition of certain properties located within the Journal Square 2060 redevelopment area.
Thanks, Sean. The administration is presenting this this resolution for the council, asking for the potential support in purchasing these two properties from the county school. The cost for these two properties in total is approximately about $16 million. The market rate for these properties is probably around 21 million. And the idea of this is to create a better footprint for affordable housing in the Journal Square area. Without this, we can almost guarantee market rate housing. We're flexible on the plans. We're open up to ideas and some initiatives. Certain individuals had discussed maybe affordable housing for seniors in particular. So, we're looking for ideas and a lot of flexibility around this, but we feel if this land is in our hands, we have more availability to provide a public benefit rather than seeing it go to a developer. So the JCRA is on a 60-day timetable, whether we're going to execute such sale, and we wanted to ask the council for some support and input on this particular sale.
Yeah, this is Councilman Solomon. A financial question first, and thank you for walking through that. Where would the money come from? Is it from the city's budget, the JCRA's budget? And if it is the city, where kind of in our line items is this coming from?
Sure. So we would have two options or three options for this. The first being that we would do a future capital bonding for this particular project, and we'll discuss those numbers. The second piece would be that the JCRA could extend the line of credit, and we would back it as the city entity. And then the third piece of that could be some type of sale agreement in which, we purchase it, create affordable housing, and then sell off a piece of one or both of the buildings. That'd be a little more tricky, and of course would include more input. But that's really the three options we would have for that.
Got it. If we go the capital route, we've now done two capital bond issues. Can we get there had been an executive order put out around how the city, the amount of capital bonding we wanted to do and debt. Can we get an update on where as a city we stand in terms of our, debt and, because I think, we don't want to make that decision in isolation. I think we want to understand how much debt we've taken on, what are our interest rates, what are our commitments, and kind of compare it to the executive order that was put out.
Yeah, Councilman, we'll be happy to provide that. In addition to that, I could also provide the future schedule of payments for debt over the next 5 years. And you'll see some of the transition bonds are coming off of our debt schedule. So we'll compare the ratio in future years as well, Council.
Great, thanks.
So, John, if I could ask about that, about this proposal. So you said there were 3 options. Can you go through that very quickly once again?
Sure. So it would be a straight up bond ordinance, capital bond ordinance from the city, and we would bond for it and buy it. The second portion would be that the redevelopment agency issue temporary notes and then we back them. And the third piece of that would be if we were to do some kind of land acquisition in which we also sell a piece of the properties to kind of counter the cost of acquisition, and then we would obtain the difference, however we discuss to structure those payments.
John, I think I want this resolution pulled. Nobody contacted me, nobody contacted the businessmen in the area, and nobody contacted any of the block associations in the area.
Okay. If I can inquire just on the first 2 options, and you can address Councilman Boggiano's request as well. But excuse me. So in those first 2 situations, it's the city acquiring it, and then the city is developing the properties. Is that the plan there with those first 2 options? Meaning that the city would build the affordable housing or partner with the Jersey City Housing Authority? How would that work?
Yeah, we have flexibility around either designating a certain developer for the purposes of the affordable housing, or we could partner with the housing authority and create some kind of cooperative. We have a lot of flexibility around it. There's no standard other than that this would be to literally just acquire the land and make sure that we kind of drop a pin and make sure that we own it for the purposes that we decide upon.
So I'm 100% supportive of acquisition to build affordable housing. I just want to know how logistically the city is not a good developer or landlord, but I mean, we could develop it, but we're not a good landlord, I would say for sure. Like we wouldn't be in the business of leasing out, renting out properties as affordable housing. The housing authority would be a different story, obviously, and they could do that. My question is also, I would say there's a 4th option, which is acquiring the property and leasing it out to private interests and maintaining it as affordable around that. Whether it be acquiring it through the city, bonding for it itself, or with the JCRA or the Jersey Housing Authority, I don't know, whichever entities would be involved in that. But then leasing it out to a private nonprofit developer so that they could, or a mixed income developer of some sort to do that. Which brings me to my question. So when we're talking about affordable housing, are we talking about 100% of the units being affordable, or are you looking at some sort of mixed income proposed development, or that hasn't been determined, or what's the case there?
It hasn't been determined. Of course, we'll do some financial analysis to take a look at what it would look like as far as that 4th option, Councilman. We're happy to address that as well if that's a consideration of the council. We're happy to entertain that question, that route as well. One of the ideas that were floated as an early perspective was senior affordability, and not necessarily a category of AMI, or nothing of that was established yet, other than we just want to kind of designate it for affordability purposes. But we're happy to have those continuing conversations with the council as to what they want to, what it may look like, and then what's financially feasible.
John, I think you got to have the conversations with me and this neighborhood and this area here. It's Ward C. All right, John? And I think this has to be pulled for now.
Councilman, I do respect your input, and I just want to clarify, this is literally just to acquire the properties. There's no plan at this point other than the option to be able to extend. Or
one of the problems at Journal Square right now is the county's taking over a lot of property. A lot of the businessmen are saying enough is enough, and now the city's taking over more property. And the square is, this has to be set down. We have to discuss this, John.
Councilman, I'm happy to discuss with you and all the council members prior to any action.
Okay.
Thanks, John. Okay, item 10.28, resolution 21-540 is a resolution appointing Carl S. Saplicki Jr. as a member of the Jersey City Alcoholic Beverage Control Board. Item 10.29, resolution 21-541 is a resolution authorizing professional service agreement with Advanced Cardiac Care LLC to assist the Municipal Council Committee on Parking for the Disabled for the Department of Administration Division of Engineering, Traffic, and Transportation. Item 10.30, Resolution 21-542 is a resolution thanking and honoring Bel Canto International Society for their work in promoting and the healing of our nation and for honoring Jersey City's frontline workers, healthcare heroes, and first responders. And item 10.31, resolution 21-543 is a resolution offering condolences to and honoring Miss K. Young Hee Park for Dr. Ayer groundbreaking technology that has proven successful in combating COVID-19. Okay, any questions, any comments at this point? All right, hearing none, may I have a motion to adjourn at 12:43 p.m.?
Motion.
Motion made by Council President Waterman. May I have a second?
Second.
Second by Councilperson Ridley. Before I take the vote, I just want to make sure I state for the record, Councilperson Prinzary arrived at 10:08 a.m., so we had 7 council members present at 10:08. So with that being said, on the motion to adjourn at 12:43 p.m., all council members present by acclamation, please say aye.
Aye.
We're out of here at 12:43 p.m. Thank you so much to Council President, members of the council, members of the staff, directors, BA, and everybody behind the scenes. Thank you for making this all possible. Without you, this wouldn't happen. So always, as I always say, teamwork makes the dream work. Stay safe, everyone. See you soon. Good night.